delighted to welcome you all to the annual Harris Lecture at the Maurer School of Law. The Harris Lecture Series was established in 1946 by a trust from the bequest of India Crago Harris in the name of her husband, Addison. It brings prominent scholars to the law school every year. Past Harris lecturers have included Derek Bell, Lawrence Tribe, Elizabeth Warren, Robert Bork, and Guido Calabresi. Today, it is my honor to introduce Reva Siegel, the Nicholas de Belleville-Katzenbach Professor of Law at Yale Law School. Professor Siegel holds a BA, a master's degree in American Studies, and a JD, all from Yale. After graduating from law school, she clerked for Judge Spotswood Robinson on the D.C. Circuit Court of Appeals, and then began her teaching career at the Bolt Hall School of Law at UC Berkeley. In 1994, she joined the law faculty at Yale. Professor Siegel is one of the most prominent and influential constitutional law scholars in the country. Much of her work explores the interaction of the judiciary, both with the other branches of government and with popular social movements, in the project of interpreting the Constitution. Her research addresses some of the most pressing questions of law and inequality, including reproductive rights and race equality. She has published countless articles in leading law journals, and her books include Before Roe v. Wade, Voices That Shaped the Abortion Debate Before the Supreme Court's Ruling, co-written with Linda Greenhouse, The Constitution in 2020, co-edited with Jack Balkin, and Directions in Sexual Harassment Law, co-edited with Catherine McKinnon. Professor Siegel is also active in the leadership of many professional and academic organizations, including the American Society for Legal History and the American Constitution Society. Her lecture today is entitled The Woman Question, From Suffrage to Abortion and Beyond. After the lecture, you are all invited to a reception in the faculty lounge on the third floor. And with that, I hope you will please join me in welcoming this year's Harris lecturer, Professor Reva Siegel.
First of all, I wanted to thank Dean Buxbaum for that very warm welcome and to say what a pleasure it is to be here, this lively crowd. And I will jump right in. I understand that we'd like to get a little bit of time for Q&A here and hope that it will continue thereafter in the reception afterwards. And I understand I have this opportunity this afternoon to meet with a number of you in sessions of student groups, and I'm looking forward to that as well. I imagine my remarks will give rise to plenty of opportunity for chat, conversations, questions, and back and forth. So, what do I mean by the woman question? Debates over equal citizenship can get entangled in particular practical contexts where they remain lodged for decades. For over 7 decades, debate over women's equal citizenship was entangled in the question of voting. For over 4 decades now, debate over women's equal citizenship has been entangled in the question of abortion. This wasn't always so, and it may not remain so, but in the late 20th century, debate over abortion became a lightning rod for a national conversation about the woman question, a conversation that, as we approach Roe's 40th anniversary, has not yet found resolution. Today, we equate constitutional democracy with the basic principle that every adult citizen is entitled to vote. But this was not true at the nation's founding. At the founding, voting was a privilege possessed by the few, not the many. It was a privilege possessed by men and not by women. It was not until the early 20th century that women gained the right to vote, secured by the 19th Amendment to the Constitution, which provides that the suffrage shall not be denied on account of sex. And it took several generations, 75 years of debate, for women to secure the right to vote. Women in the abolitionist movement first claimed the right to vote on equal terms with men in the decade before the Civil War, and pursued that right for some 3/4 of a century until they secured constitutional recognition of the right in 1920. During that time, over those decades, the question of women's suffrage was referred to simply as the woman question. The debate over women's suffrage was referred to as the woman question because the debate over women's suffrage raised fundamental questions about women's roles, nature, and place in the constitutional order. Opponents of women's suffrage argued that the prospect of women voting was inconsistent with women's family role and with women's nature. Women's rights advocates countered with equality arguments premised on the view that women needed the vote in order to discharge their obligations to the family, and with equality arguments premised on the view that the individual female citizen and not the state should be responsible for making those kinds of decisions. Today, voting is no longer the site of struggle over the woman question. Most members of our society, most at least, believe that women deserve the vote in a democracy independent of their husbands' and fathers' views. No longer does the law prohibit women's independent exercise of the suffrage. Instead, law protects women's right to vote as they choose. But today I will be arguing that this society has not settled the woman question. It has continued to debate the woman's question in new contexts. For the last 4 decades, debate over abortion has been haunted by the woman question, much as the debate over suffrage once was. For the last 4 decades, abortion has been the site of struggles over the woman question, just as for decades, schools were the site of struggles over the race question, or today the institution of marriage is the site of struggles over the standing of gays and lesbians. In analyzing the abortion debate as a continuing debate over the woman question, I break with the general understanding about the kind of disagreement at the heart of the abortion debate. The abortion debate is generally thought to concern the question of when life begins. But the question of when life begins is not the only question that makes the abortion debate explosive. As I will show, the woman question has been an express part of the abortion debate since the years before Roe. In what follows, I will give a bit of background on the origins of the modern debate and then sample that debate at several points over the decades to show that debate over the woman question was an explicit and central part of the abortion debate that changed shape over the decades. In the interest of time, I'll divide my remarks into 3 periods: the era before Roe, which is in 1973, the era before Casey, which was decided in 1992, and the era before the Carhart decision, which was decided in 2007, the Supreme Court's most recent abortion decision, upholding the Partial Birth Abortion Ban Act. Rather than discuss these cases in the course of my remarks, which I'm hoping are at least familiar to many in the audience, I'll be discussing the debates in the popular sphere around those cases. And then at the end of my remarks, I will try to talk a bit about the influence of popular debates on the Supreme Court's decisions at the very close of my lecture. This is a tall order, and so I'll proceed rapidly in the hopes that I can at least show you some of the connections between the larger popular debate and the directions of our constitutional law. So I start before Roe. By the way, in talking about some of these sources, I'm talking about sources that are in the book that Dean Bucksbaum mentioned, and I actually had given a digital copy of this book to Professor Johnson, who can circulate it to anyone who's interested. It contains sources from the debate over the abortion issue before the Roe decision on all sides of the conversation, and Linda Greenhouse and I are making it available to people in a Creative Commons license form so that people who are interested in looking at these sources, no matter what your views, can take a look, and Professor Johnson can circulate that source if people are interested. Abortion and contraception were lawful at the time of the country's founding, at common law, and then criminalized state by state in the mid to late 19th century. For the century thereafter, no woman could have an abortion unless a doctor declared it was necessary to save her life, a term sometimes construed generously to include physical and mental health for those women who had money and connections to the right doctor. By the 1960s, a variety of advocates began to urge reform of abortion law. At this point, in the 1960s, calls for reform had nothing to do with women's equality or claims about women's citizenship. The campaign to reform abortion law in this period was led by doctors advancing concerns of public health. They emphasized that laws criminalizing abortion subjected women to risk of death and infertility, pointing out that those risks were borne disproportionately harming poor women. and women of color who could not afford to pay the right doctor or travel to a jurisdiction where abortion was legal. If the public health case for abortion reform raised questions of equality, it was to argue that abortion laws ought to be the same for wealthy women and poor women, white women, and women of color. The public health case also focused on dilemmas faced by pregnant women who contracted measles or accidentally ingested toxins, such as thalidomide, known to induce severe fetal abnormalities. Initially, at least, public health advocates did not challenge the criminalization of abortion. Rather, they offered paternalist justifications for expanding and codifying exceptions to the criminal ban. Public health advocates helped enact laws allowing women to obtain an abortion if women could persuade a committee of doctors that certain excusing indications were present that abortion was necessary for the pregnant woman's physical or mental health, or because the pregnancy was the result of rape, or because the fetus was severely impaired. Over the course of the 1960s, a number of states, many in the South, enacted indications laws liberalizing exceptions to criminal bans on abortion. By 1974, states, most prominently including New York, enacted what were termed periodic legislation that allowed abortion early in pregnancy without restriction as to reason or justification. No committee was involved to decide whether the person in question, the woman in question, had sufficient reason. But by 1970, the range of arguments for decriminalizing abortion had multiplied. Advocates in a nascent environmental movement concerned about scarce resources in an overpopulated planet were advocating separating sex and procreation as a public regarding practice, while on other fronts, a sexual revolution was transforming norms concerning non-marital intimacy. Advocates in each of these movements supported liberalizing access to abortion. And a newly mobilizing women's movement, growing from the ranks of a civil rights movement, from the anti-war movement, and from the labor movement, also began making arguments for decriminalizing abortion of a wholly new kind. In the 1960s, the women's movement was beginning to mobilize for equal rights in employment, family, and politics. Growing numbers of feminists understood criminalization of abortion as a symptom and a symbol of an unjust and an unequal society, a society that enforced a double standard for women in sex, in family roles, and in the workplace, and in politics. This is a new standpoint on the problem. In Chicago in February of 1969, Betty Friedan addressed a convention called to found the National Abortion Rights Action League. She titled her remarks, "Abortion, a New Civil Right." This is like a new way of talking about the issue, at this point not heard of. Women are denigrated in this country because women are not deciding the conditions of their own society and their own lives. Women are not taken seriously as people. Women are not seen seriously as people. So this is the new name of the game on the question of abortion, that women's voices are heard. Women are the ones who therefore must decide, and what we are in the process of doing, it seems to me, is realizing that there are certain rights that have never been defined as rights that are essential to equality for women, and that were not defined in the Constitution of this or any country when the Constitution was only written by men. The right of a woman to control her reproductive process must be established as a basic and valuable human civil right, not to be denied or abridged by the state. We are at a new stage here in the whole unfinished sexual revolution in America, the whole revolution of American women toward full equality, full participation, human dignity, and freedom in our society. My only claim to be here is our belated recognition that there is no freedom, no equality, no full human dignity and personhood possible for women until we assert and demand control of our own bodies over our own reproductive process. This is an unheard of claim around the issue of abortion at the time that this is said in '69. Feminists saw laws criminalizing abortion as denying women's dignity, as depriving women of bodily autonomy, as importantly, as denying women voice and authority, a role in determining their own sexual and family roles. They sought voice for women in politics as well as in the decision whether or when to bear a child. This is the new name of the game on the question of abortion, Friedan argued, that women's voices are heard. To accomplish this, feminists claim for the first time a constitutional right for women to have a voice in the decision whether to carry a pregnancy to term. Securing constitutional protection against criminalization of contraception and abortion would protect women's freedom to say yes to sex while still retaining control over the timing of motherhood. But in the feminist imagination of this era, constitutional protection for contraception and abortion alone was insufficient to create freedom. The movement nested its claim for control of decisions about pregnancy in a broader range of claims, seeking support for those who parent. A year later, on the 50th anniversary of the 19th Amendment's ratification, the women's movement held a nationwide strike for equality. Feminists argued that in 1970, equal citizenship for women required more than an equal right to vote. The women's movement honored the half-century anniversary of the 19th Amendment's ratification with several claims for constitutional change. Feminists sought ratification of the Equal Rights Amendment and 3 additional claims, which they asserted would give women equality with men. They sought equal employment opportunity, publicly supported child care, and abortion on demand, by which they meant not access to abortion on a whim, but rather access to abortion without having to give reasons to or seek the permission of a committee of doctors, meaning not under an indications model, but rather on a periodic legislation. The movement at this point is seeking for women control over the conditions under which they conceive and rear children. This is part and parcel of the demand at the time of the ERA. The entrance of feminists into the abortion conversation in this period both increases support for liberalization of abortion laws and also energizes opposition. And what I want to be saying or showing in the remainder of my remarks here is that over time it will change the way in which opposition to liberalization of abortion law is argued. So what I'm going to do first is to show you what the extant opposition to abortion looks like in the 1960s and how it changes shape over time in response to the feminist arguments of the era. When abortion reform begins in the 1960s, opposition to public health reform was predominantly Catholic-led. In the 1960s, most Protestant denominations, including evangelicals such as the Southern Baptist, accepted the case for therapeutic abortion. This is an interesting feature of the 1960s, and distanced themselves from the abortion issue, which they viewed as a Catholic issue. So it's primarily seen as a Catholic issue in this period, not a pan-Christian issue. Anti-abortion arguments of this era typically rested on fundamentally different premises than the feminist argument. For example, Catholic arguments against abortion generally rested on the view that sex is for the sacred purpose of procreation, of creating life, and consequently did not support women's interest in saying yes to sex while retaining control of decisions about whether and when to parent. To the contrary, it was assumed that the two, sex and procreation, should always be tied together. Humanae Vitae, an encyclical promulgated in 1968, condemned both contraception and abortion together as contrary to a Christian understanding of marriage. In their most familiar form, Catholic anti-abortion arguments of the 1960s condemned abortion as the taking of human life and endeavored to translate that view, which in the 1960s other Christian denominations did not fully share, into secular terms. Jack Wilkie, who would soon emerge to lead the National Right to Life Committee, employed photos of fetuses, scientific and ethical arguments in his best-selling Handbook on Abortion, arguing that if the fetus is, quote, human, he or she, must be granted, I'm quoting now, the same dignity and protection of his life, health, and well-being that our Western civilization has always granted to every other human being. Wilkie, who has lately gained notoriety in the Todd Aiken's legitimate rape debates as a medical doctor prepared to argue that pregnancy is less likely to result from rape than from other acts of intercourse, opposed exceptions for rape in his 1971 handbook in terms that conspicuously do not engage with the feminist case for abortion rights, which is certainly audible by the time of the handbook's publication in 1971. But by the early 1970s, new voices were beginning to join the National Right to Life Committee in opposing abortion, and these newcomers began to attack feminist arguments for the abortion right. As I've elsewhere recounted, in the 1972 presidential election, Republican strategists are looking for new ways to encourage conservative Catholic voters to abandon their historic ties to the Democratic Party and realign with the Republican Party, which in this era, interestingly enough, is basically pro-choice. There's a flip-flop, just like you can't assume where Protestant denominations are in this story in the pre-Roe period. You also can't assume Democrats and Republicans. They're actually flipped. President Richard Nixon, who initially took policy positions supportive of liberalization, began to reverse course and call for restrictions on abortion in terms directed at Catholic audiences and in language sounding in the sanctity of human life. As the campaign progressed, however, Nixon widened his attack on abortion in terms designed to appeal not only to Catholics, but to the quote-unquote silent majority, who he discerned were concerned that youth movements, the anti-war movement and feminists and those engaged in the so-called sexual revolution, hippies for short, were a threat to traditional family values. In August of 1972, Kevin Phillips, author of The Emerging Republican Majority and a key architect of the Republican Party's Southern strategy, published a New York Times Magazine article entitled "Why Nixon Will Win." In it, Phillips promised that Republicans would attack aggressively on social morality themes and warned that in the fall campaign, Republicans would be tagging McGovern as the AAA candidate. Acid, amnesty, and abortion. Has anyone ever heard of this? So, what's acid? Okay, you know what that is. Does anyone know what amnesty stands for in this? Okay, draft dodgers and abortion. So, acid, amnesty, and abortion. So, he said that tactics like this will help link McGovern to a culture and morality that is anathema to middle America. So this is a new kind of anti-abortion argument, this AAA argument, acid, amnesty, and abortion. All right, so what's changing in this argument against abortion here? So the AAA attack on McGovern is condemning abortion rights as part of a permissive youth culture that's corrosive of traditional forms of authority. The objection to abortion rights is not that abortion is murder here, sanctity of human life kind of argument, but that abortion rights, like the demand for amnesty, validated a breakdown of traditional gender roles that required men to be prepared to kill and die in war and women to save themselves for marriage and devote themselves to motherhood, right? So in the AAA framing, abortion stands for gender trouble. Drawing on these same sets of associations between abortion and feminism, Phyllis Schlafly drew abortion into a campaign against the Equal Rights Amendment in this same time period. Schlafly's first published attack on the ERA in February of 1972 complained, "Women's lib is a total assault on the role of the American woman as a wife and mother and on the family as the basic unit of society. Women's libbers are trying to make wives and mothers unhappy with their career, make them feel that they are second-class citizens and abject slaves." These are quotes from feminist talk of the era. "Women's libbers are promoting free sex instead of," that's the idea of sex decoupled from procreation, "free sex instead of the slavery of marriage. They are promoting federal daycare centers for babies." See, this is the demand that on the right. "They are promoting federal daycare centers for babies instead of homes. They are promoting abortions instead of families." So this is the attack on the ERA, is coupling ERA and abortion. So observe that the Republican Party's AAA argument and Schlafly's anti-ERA argument are arising outside of the ranks of the formal anti-abortion movement itself, but riding alongside of it. So this is the Republican Party that is making this argument, and it's the anti-ERA movement. But they are beginning to make negative associations with abortion and ERA, or abortion and anti-feminism. These new forms of anti-abortion argument in the pre-Roe period are sounding themes that develop into core forms of anti-abortion argument in the post-Roe period as we move forward into the 1970s. By 1977, Schlafly is helping to found the pro-family movement, which is part of the whole campaign to defeat the ERA, the Equal Rights Amendment. The argument is that the ERA is going to constitutionalize the abortion right, and the campaign against the ERA is both anti-abortion and anti-ERA, and all of that is pro-family. Those are the frames that Schlafly builds in Eagle Forum and that Beverly LaHaye builds an organizing evangelical Protestants in Concerned Women for America. So this whole anti-ERA campaign is also taking on the campaign against abortion and unfolding the whole of this into a pro-family movement, which is also pro-life. These are frames that you recognize as very familiar frames to the modern ear. The Republican Party is also building this same set of frames together. It's not just happening in the anti-ERA campaign. Richard Viguerie and Paul Weyrich are building the new right and trying to continue to recruit social conservatives and Catholics historically associated with the Democratic Party to join the Republican Party in the campaign to elect Ronald Reagan in 1980. And I'm going to read you from the 1980 Republican Party platform, which both associates and equates pro-life and pro-family causes. So these, the anti-ERA and the anti-abortion causes. Here's the plank. We will work for the appointment of judges at all levels of the judiciary who respect traditional family values and the sanctity of innocent human life. So the two causes are wedded together here. This is what I mean about the abortion question getting entangled with the woman question. This is the campaign against the ERA and the campaign against abortion are tangled up together here. So to this point, we've seen how in the 1970s, the feminist movement advanced the argument that women's control over decisions about bearing children was a critical element of women's equal citizenship, which in turn elicited a counterclaim from Republicans and from an emergent anti-ERA pro-family movement that abortion rights posed a threat to traditional family values and the sanctity of human life. These two claims of pro-life and pro-family riding together, to use the language of the Republican Party platform. When we get to the early 1990s, if we move ahead in this story, say the period after the Casey decision and after Clinton's election, if we're in the 1990s, we see another development, a really remarkable development in the entanglement of the abortion question and what I'm calling here the woman question. Growing numbers of abortion opponents, those who oppose the abortion right, change course, and instead of opposing feminist initiatives, begin to assert themselves as true defenders of women's rights. So instead of opposing women's rights, say that in opposing abortion, they are in fact defending women's rights. There's an inversion here. And the claim about women's rights goes inside of anti-abortion argument. We begin to get an inversion here. And the claim begins to be that in order to protect women's health and freedom, what sounds like the women's rights claim, it's necessary to criminalize abortion. Anyone recognize this claim? It's the emergence of the woman protective claim for criminalizing abortion. In order to protect women's health, in order to protect women's freedom, you need to criminalize abortion. Does this claim sound familiar to anyone? I'm seeing some heads, yes. So I'm talking about the emergence of this claim as being an inversion of the arguments of the adversaries. Till the 90s, there had been traveling side by side the idea that you were opposed to abortion and opposed to women's rights, but now inside the case for opposing abortion is the claim that it is a women's rights claim. I'm going to read you from Jack Wilkie, whom I had read to you from earlier. He's the author of the Handbook on Abortion in 1971 and the president of the National Rights Life Committee, so not a marginal figure, but a core figure in this story. And I'm going to read his account of this series of developments. He's describing the interest in woman protective arguments that develops in the anti-abortion movement in the 1990s. He's looking back on this from the standpoint of 2001, looking back at these developments. We had been making steady progress in educating the nation beyond a reasonable doubt that human life in its complete form began at the first cell stage. This is the pictures, the photographs that he used in the 1971 Handbook on Abortion. He was very, millions of copies of the Handbook on Abortion. You see these are so classic that you don't know how powerful he was in first attaching these photographs to the argument for opposing liberalization of abortion and keeping it criminal. So we had been making steady progress in educating the nation beyond a reasonable doubt that human life in its complete form began at the first cell stage. Then pro-abortion activists changed the question. No longer was our nation arguing about killing babies. The focus through their efforts had shifted off the humanity of the unborn child to one of women's rights. They developed the effective phrase of who decides. Pro-lifers were still teaching in the traditional method they had brought such astounding and continuing success until that time. They were still proving that this was a baby and telling how abortion killed the baby. However, increasingly these facts fell on deaf ears, for this did not address the new argument of women's rights. This had to be answered, but we did not know what the effective answer was. The only way to find out would be by extensive market research. That's how they had come up with the idea of changing the question to who decides. That's how we would discover how to countermand their new sales pitch. This would require extensive research, focus groups, polling, and the testing of new ideas. We did the market research and came up with some surprising findings. The public felt that pro-life people were not compassionate to women, that we were only fetus lovers who abandoned the mother after birth. They felt that we were violent, that we had burned down clinics and shot abortionists. We were viewed as religious zealots who are not so well educated. Clearly their image of us was one that had been fabricated and delivered to them in the print and broadcast media by a liberal press. After considerable research, we found out the answer to their choice argument was a relatively simple, straightforward one. We had to convince the public we were compassionate to women. Accordingly, and then he describes, was born the slogan, "Love them both," and in fact the third edition of our question and answer book has been so titled specifically for that reason. So the argument evolves into one that's just fetal protective to one that is also fetal protective and woman protective. During this same period, I have the long story of this evolution of the argument played out in an article called The Rights Reasons, which I could share with you if you want to see the extensive sourcing on this evolution. During the same period, David Reardon, who's a key proponent of the woman protective argument and whose research is regularly cited in arguments in support of these kinds of claims, also elaborated the kinds of political justifications that led proponents of the criminalization of abortion to begin to worry about invoking protection for women as well as protection of the unborn in their arguments. And in a book that is called Making Abortion Rare, which is partly troping off of the Clinton making abortion safe, legal, and rare, talks about the need to, here I'm now going to quote, "The abortion debate is about women's rights versus the rights of the unborn," right? So it's either or. He says, wrong. This is the way that pro-abortionists in the media have framed the debate. They have consciously defined this issue in terms which polarize the public and paralyze the middle majority, the fence-sitting 50% or more who feel torn between the woman and the child into remaining neutral. We must insist that the proper frame for the abortion issue is not women's rights versus the unborn, but rather women's rights and children's rights versus the schemes of exploiters and the profits of the abortion industry. So you see the evolution of the claim comprehending not only fetal protection, but also protection of women as well, and the evolution of what was an argument that had been once really focused on the dignity of protecting human life into protecting both, and claim of women's rights now starting to morph into a claim that comprehends also claims about the criminalization of abortion. How would using the criminal law to control women help women? Reardon's response was to insist that women who have abortions don't really want them, they're coerced into the procedure, or they don't really grasp it, and therefore criminalizing abortion is going to free women into doing what it is they want, which is women by nature want to bring a pregnancy to term, and therefore the criminalization of abortion will free them to choose the end which they want, which is to bear the child. So here we get to the claim of women's nature. Okay, watching the time here, I'm going to move to the law, even though there's much about the woman protective argument which you can imagine that could bear an entire lecture's discussion. So our case law reflects this struggle. There's years of this struggle. In 1973, when the court decided Roe, feminists had only recently joined the abortion debate. In fact, the court that decided Roe understood the question of public health, of women's health, and scarcely grasped the women's rights claim. It doesn't touch, really. If you read the case in your constitutional law class, you're not going to find much evidence that these claims were in issue. You won't hear them in the case. The court's 1992 decision in Planned Parenthood versus Casey reaffirming and dramatically limiting Roe reflects much more clearly than Roe the views of antagonists in the abortion debate, both feminist advocates for abortion rights and those who passionately oppose access to abortion. In reaffirming and narrowing Roe, Casey enlarges the justifications for the abortion right. The Casey decision identifies the equality values that freedom to decide about family roles secures for women. Now I'm reading from Justice Kennedy's opinion, what is held to be Kennedy's opinion in here. Her suffering is too intimate and personal for the state to insist without more upon its own vision of women's role, however dominant that vision has been in the course of our history and our culture. The destiny of the woman must be shaped to a large extent on her own conception of her spiritual imperatives and her place in society. Casey ties constitutional protection for women's abortion decision to the understanding forged in the court's sex discrimination cases that government cannot use law to enforce traditional sex roles on women. This is an understanding of the abortion right wholly absent in Roe. Sex equality values everywhere inform the opinion's reasoning about the Constitution's protection for a woman's liberty to decide whether to bear a child. At the same time, Casey adopts an undue burden test that sanctions regulation of the abortion right throughout the pregnancy to promote the state's interest in protecting unborn life, so long as such regulation allows women the ultimate choice whether to continue or end a pregnancy. The court's aim seems to be to allow citizens who oppose abortion opportunities to express that ethical view to women who are pregnant throughout the pregnancy, a concern that Roe did not endeavor to accommodate. The court's 2007 decision, the Carhart decision, upholding the Partial Birth Abortion Ban Act, reflects the emergence of debate over the woman protective anti-abortion argument. The Partial Birth Abortion Ban Act was plainly designed with concern about unborn life in view, although the legislation was incremental rather than absolute in protecting unborn life. It didn't forbid certain abortion at certain stages of pregnancy, but rather regulated how it could be performed, not whether. So that's what I mean by incremental regulation rather than absolute. In the course of upholding the statute, Justice Kennedy included language in his opinion suggesting he might be open to women protective arguments that were expressed in some amici briefs. This in turn prompted Justice Ginsburg and 3 other dissenting justices to challenge Justice Kennedy's reasoning with an express appeal to the court's equal protection sex discrimination cases. Casey had reasoned from equality values, but in Carhart, 4 justices expressly appealed to the court's equal protection cases as a basis for constitutional protections for the abortion right. As more and more legislation is enacted on the woman protective model, the question the court took up glancingly in Carhart appears likely headed for judicial resolution in the near future. It represents for us the woman question in the languages of the 21st century. What protects women's welfare and freedom? What best protects women's welfare and freedom? Giving constitutional protection to women's right to decide whether to carry a pregnancy to term, or overturning Roe and sending the question back to the states, which severally can debate whether, once again, to impose criminal bans with or without exceptions on abortion. The court's liberal justices have now begun to reason about abortion by appeal to the authority of the Equal Protection Clause, The question is whether Justice Kennedy might ever be moved to do so. James Bopp, longtime lawyer for the National Right to Life Committee and architect of Citizens United, has urged anti-abortion advocates to challenge Roe incrementally and cautioned against pressing personhood amendments or other absolute restrictions on abortion. In Bopp's view, a constitutional challenge to a personhood amendment might provide the occasion for Justice Kennedy to endorse Justice Ginsburg's understanding of the abortion right. In a strategy memo to the anti-abortion movement, this is where I'm going to wind up, Bopp warned, but if the U.S. Supreme Court, as presently constituted, were actually to accept a case challenging the declared constitutional right to abortion, there is a potential danger that the court might actually make things worse from his standpoint than they actually are. The majority might abandon its current substantive due process analysis, reading fundamental rights into the liberty guaranteed by the 14th Amendment against infringement without due process, in favor of what Justice Ginsburg has long advocated, an equal protection analysis under the 14th Amendment. In Gonzalez against Carhart, the dissent written by Ginsburg, in fact, did so. And then he quotes from her, "Legal challenges to undue restrictions on abortion procedures do not seek to vindicate some generalized notion of privacy. Rather, they center on a woman's autonomy to determine her life's course and thus to enjoy equal citizenship stature," close quote. He goes on, "A law prohibiting abortion would force Justice Kennedy to strike down the law, giving Justice Ginsburg the opportunity to rewrite the justification for the abortion right to the court. This is highly unlikely in a case that decides the constitutionality of such things as partial birth abortion bans, parental involvement laws, women's right to know laws, waiting periods, and other legislative acts that do not prohibit abortion in any way, since Justice Kennedy is likely to approve such laws." Like Justice Ginsburg, James Bopp believes that an abortion right expressly and textually anchored in the Equal Protection Clause would be much harder to disentrench. So, on the eve of Roe's 40th anniversary, we do not yet know its fate. However the court decides the question, it is not likely to settle the abortion question for this generation. And should the abortion question one day find settlement, even that would not be likely to settle the woman question for generations to come.
I know some of you may have to leave for class, but I think there's time for some questions for Professor Siegel here before the reception. Any? Dawn?
So, I'm interested in hearing more about the response from the pro-choice side in your research, especially in recent years, as the Republicans and Dave Bearden talk more about the women protective arguments. My feeling is that the pro-choice groups in recent years have continued to feel like talking too much about women's equality is harmful in terms of reaching middle America. And so as you were talking about the opponents of abortion embracing that, which, I've read everything you've written and it's all wonderful and I agree with your assessments, but it's just interesting to me that on the other side, there's been, during that same period, concern about expressly embracing the Justice Ginsburg approach as part of the political movement. And just wondered if you had reactions to that. And whether, in just very recent years, whether it seems like maybe the opportunity for progress, arguing in those terms, might be increasing.
Well, I would completely differentiate what's to be said in law from what's to be said in ordinary conversations with people, or politics, if you will. So and even in law, I have written talking about constitutional arguments in dignity, which I think is, if we're talking about arguing, for example, to Justice Kennedy, that seems to me an infinitely better register in which to make the case than equality, if we're talking about this particular Supreme Court, as opposed to Supreme Courts generally. But there's a reason that even James Bopp is worried about this as a legal matter, because if you recognize an equal protection argument, it's not an easy thing to say, oh, never mind, to an equality right. It's easier for the court to say, but it's a striking matter that the court has chosen the path of chipping away at Roe rather than overruling it. That seems to be congenial, at least to O'Connor and to Kennedy, more than the overruling. And the equality argument would make it even harder for anyone expressly to overrule. It's a different matter what it is one says in talking about the women protective argument. And I even hesitate to, it's a crazy tour through our history to talk about this in 45 minutes. I even hesitate to even raise the women protective argument without saying a whole lot about it. And really the last thing I'd say is sex equality, because just let's start with the coercion argument. There's a whole lot that needs to be said. For example, to go all the way back to what it is that you wouldn't say sex equality to an individual woman who's facing a question about whether or not to end a pregnancy when she's feeling unfree about it. I think a first feminist argument would be to say we want to support people in making decisions about parenting in which the community supports them in making the right decisions that they want to make, including getting them the resources to get to the decision that they want to get to. And that should cut across all kinds of lines. And that's an equality result. And it's one that the women's movement in the 1970s was trying to make. And one doesn't need to start with issues of abortion to say that people make decisions under constraints, and as a community we want to try to lessen the constraints on them in the first instance. And then you could go to the next question, which is under constraints of a kind that we as a community haven't found the resources or the means to abate, then it could turn out that where we're not going to intervene in somebody's life circumstances, it may be the second order best decision they can come to, and that may be the reason that we want to give them control of their choices. I want to go a long way along that conversation with someone rather than just invoking the idea of equality, which is at such a high level of abstraction, it doesn't mean anything to people concretely. So I guess I would say, what's the arena and where are we in the conversation? I could show how all of that's connected to an understanding of equality, but I wouldn't start the conversation there in the first place.
Yeah, I'm fascinated by the women protective argument, the most modern version of it. And the way I've heard it in the popular culture is all these women who were sorry they had abortions and the psychological damage that it did to them. Is there also an argument that that actually reverts back to the discrimination argument or the women's civil rights argument, that the sexual revolution has been bad for women, that you were better off before?
Well, I think there are lots of strands of that there. I think there's, but I mean, to take a step back from that one, people regret all sorts of things. And who doesn't? But there's a long step between regret and legally disabling them from taking the act in the first place. Like, for example, people may regret getting married. We don't bar them from getting married or alternate. I mean, it's a sort of a rather steep cure for the problem. So again, it's a case in which you don't want to be harsh in response. You need to play out what's at stake in the objection. Sometimes I think, I have given you in these excerpts situational reasoning by leaders of the movement as to why some longtime leaders of the anti-abortion movement found themselves interested in the woman protective argument. It's another thing altogether why in the ranks of the anti-abortion movement, women have been moved to speak in this register. I think that, and when I, in this paper, The Rights Reasons, where I describe mobilization around the woman protective argument, I actually draw a distinction between leadership and popular appeal at the level of base. I think that for many, having an opportunity to talk about life experience and harm, having an ear for post-abortion grief may speak out around this, may even be the only place where people have counseling or support groups of any kind, and they may have many forms of regret and pain in their life, and if this is the one where they have a chance to speak, this may well be where they need to speak or their best opportunity to speak. But there's a big difference between saying that for some women this is a source of pain in their life and then using the law to disable all other women from action. Again, there's a mismatch between somebody's difficulty and using the criminal law as a form of remedy. And indeed, when I've written on the question, the thing that I generally objected to was less the diagnosis than the mismatch between the diagnosis and the remedy. That's what's been suspicious about. Because you could think many things you'd do in response by way of potential support, counseling, other forms of material intervention, short of just criminalizing the decision point for everybody involved, which seems like a draconian and mismatched form of relief. Some students, yes.
Hi, do you think that we're ever going to settle the abortion issue? What do you think the next issue would be that would play out with the women?
Oh, what a great question. What do you think?
No idea.
We're very far from settling the abortion question, and I'm not sure what it would attach to, you know. I tend to see these things, I'm going to think on that a really long time because I'm not done writing on it. It's a beautiful question. I want to have a chance to think on it, and I will. I think these things emerge partially through historical accident. You know, some things more than others have the property of tapping group conflict in a way that makes them especially propitious, but there might be an element of accident. I don't know if 20 years ago we could have identified that marriage would have been the issue around which our whole national conversation around sexual orientation would have taken place, you know. I think it would have surprised many people. So, you know, I don't know that one would have identified this 20 years before it happened as the one around which this would have happened. But I want to think about it. It's a great, great question. Yeah.
If you go back to Griswold and Roe, these contraception and abortion cases, to me the fundamental right that was appreciated in those cases was the right to privacy, the right to be let alone. And to me this was a male, pro-choice should be a male issue from that point of view, as well as women. I mean, men's lives are affected by unwanted pregnancies and unwanted births and so on. How is it that pro-choice simply became a women's movement and sort of men were discarded on this issue?
Well, I think that there have been times when that wasn't the case, and then there have been points in the mobilization where it tended to have that form. I suspect that in the heyday of Friedan herself wouldn't have seen things that way, but there were points in the women's movement where there was very much a kind of women go it alone tenor to the whole thing. There's nothing at all either feminist or promising about an agenda that says that parenting should be shared, that's promoted simply and only by women. It can't really succeed on those terms. And I think that there's one argument that says women's voices need to be heard in a way that they weren't heard, and another argument that says that only women's voices should be heard. That's a problematic version of it. It's tricky when you get to the abortion issue where there's an effort to keep an asymmetric decision rule. So there's like a last loop in there, which is complicated, and sometimes that's justified on the notion that it's, in the end, women's bodies physically that are the decision. Sometimes there's the notion that in the end, women are often winding up as a practical matter as single caregivers. But I don't think it's the case that only women are supporters of pro-choice today, or only women are in the movement, but they have taken a lead. And when it's argued in a way that it's only women, but when it's only women, that's hugely a problem. Yes?
Yeah, I was interested in how you're saying that the sort of litigation strategy for trying to limit abortion has kind of disavowed personhood amendments in favor of these smaller sort of restraints on the abortion right. And it kind of reminds
One has, I mean, not, he's making, Bob is making this claim because he's trying to do this, but he's not wholly succeeding.
And my concern was it kind of perversely struck me as being similar to the way that civil rights act pushed forward, in that by leaning the court towards these small concessions, you eventually can get an overturning precedent. And is that a similar kind of strategy, that by getting these small concessions that people will eventually be able to?
That is the debate. It's hotly debated in the anti-abortion movement. That is, it has been led by National Right to Life Committee and Americans United for Life, who support litigation through incremental change on the model that the NAACP used when it approached Brown. And there are those who wholly and passionately oppose it. In fact, Carhart was condemned by people within the more extreme elements of the anti-abortion movement as legitimating like how to perform an abortion, because it's saying how you must do this thing rather than saying you may not do this thing. So there's a totally passionate debates within the anti-abortion movement about what's the right strategy. It's a point of division, right? That's why he's writing this memo. He's trying to stop people who are doing more radical interventions. They don't trust him, however. It's like a debate, right? Movements splinter in this way. All movements have internal divisions. This is an instance of it.
I think there's time for one last question, and then I hope you can all come upstairs to the faculty lounge to continue talking with Professor Siegel. Susan?
Thank you for this wonderful paper. I'm really struck by your description of the women protective arguments and by the difficulty that they may pose for the pro-choice movement in terms of response. And I'm wondering whether you think that part of that difficulty comes from the fact that this is a kind of argument that plays on one of the central, dilemmas for gender equality advocates generally, which is a sort of choice between presenting women as victims, subject to all sorts of coercion and constraint, and presenting women as autonomous actors. And the difficulty, of course, is, you're damned either way, right? That is, neither of those is an adequate picture of what's actually going on. But there's the constant pressure to be pushed into one or the other of these camps. And the difficulty with the women protective argument is that it's claiming the sort of the victimhood position, right, on behalf of women. Poor women, they're constrained in all these ways, we have to protect them, sort of pushing the pro-choice response into an autonomy,
To the autonomy argument.
which is very uncomfortable and doesn't really capture everything, and therefore making it difficult to respond.
Yeah, Jeannie Suk has a paper in Columbia that's basically saying that the fault or the source lies in feminism, because she's tracing the genealogy of this whole argument to victim feminism and saying that saying that the tropes come from feminism itself. Rightly or wrongly, that at least shows that feminism has ambivalences about which pictures it has of women. And you're absolutely right that when you face down this highly victim-centered talk about who women are, the natural rejoinder is to sort of sound in autonomy, which actually gives a very thin picture of women as agents. Of course, women, when they're making choices, are making massively constrained choices. And so you need to back off the criminalize, decriminalize, and say, that may not be a sufficient, that binary is not sufficient as a remedy. Let's go into a thicker account of where women are and see whether we have any other responses other than criminalize, not criminalize abortion. And then it turns out there are many other available interventions which may be a lot more helpful than that one remedy. But this is only coming in around that one question. And there seems to be little or less interest, I think, in interventions on those other grounds. Now it raises, and perhaps it's a nice and a happy way to end the lecture, the really rich question of whether it's possible to make coalition partners across lines, pro-choice, pro-life, in interventions that would support women in making different decisions to carry pregnancy to term that don't involve criminalizing abortion. There are some grounds where compromise and coalition is possible like that, and then some places where polarization makes it impossible. So.